I'm here, brother. I'm here.
Okay. The appeal has been partly allowed and the conviction and sentencing has been converted from 302 to 304 part 2 and 7 years of RI with fine of 15,000. And we record our appreciation for the assistance by Sri Kolita.
Oblige it.
Yes. Yes.
Let the matter be listed for motion tomorrow.
Motion.
Motion.
Okay.
Highly obliged.
It is all okay. Let me mention item number 4 to 7, my lord.
Yes.
My lord, I am led by Digonto Das, the senior counsel, my lord. My lord, there's some personal difficulty today. So could it be on some other? I've taken the consent from the.
Okay. 4 to 7. Yes. Which date?
My lord, could it be?
A prayer for adjournment has been made on behalf of Sri D. Das, appearing for the respondent number.
My lord,
Respondent Cotton University.
Cotton University.
Appearing for the respondent Cotton University.
70.
Full stop.
70.
Accordingly, matters are adjourned to be listed on.
18th of this month. Wednesday.
18th is okay for Mr. Chaudhary.
Indeed. Indeed, Lordship.
Oh, today is what? On 18th, okay.
18.
Hmm.
Deeply obliged.
18/6.
May I please your topic? Okay, I beg to mention listing of one WPC 3899/2023, my lord. It is relating to promotion of headmaster, my lord. So on last occasion, when matter was read on 15/7/2024, so our honorable court has directed us not to declare the result. Without leave of the court, my lord. So, my lord, day after tomorrow, my lord.
You are for the department.
Yes, my lord, I am for that.
On Friday.
Wait, please, my prayer for listing of a motion matter for tomorrow. I am deeply obliged.
Wait, please, your lordship. Lordship, with the consent of the petitioner, I beg to mention item 31. If after a week, lordship.
31.
I don't think to check. I can put 31. There was urgency on my part also, but the affidavit that is going to be filed is important for the petitioner also. So, my lord, can this matter be a date be fixed, my lord?
You want time for what, Mr. Upaman?
But affidavit.
For
Affidavit. For affidavit. 2020 matter. You have not filed affidavit.
No, my lord, affidavit is filed. They said
On behalf-
rather than new notification or new something has come up, so they want to bring that on record. On last occasion, the status.
Okay.
Lordship,
On the prayer of Sri D. Upamanyu, Learned Standing Council, Higher Education Department, matter is adjourned by 2 weeks. 2 weeks to enable filing of additional affidavit. We'll
Yes,
file
yes,
additional
yes,
affidavit
yes, my-
to bring on record subsequent development. Para, Miss H.G. Barua, Learned Counsel for the petitioner, has however expressed urgency. Para, in view of the above, list this matter when?
My lord, my lord is taking before or after vacation. If after vacation on 15, then
On 15th.
15
On
July.
15th.
15 July.
My lord, interim orders are there.
15 July, interim order passed earlier to continue till the next date of listing.
Obliged, my
Highly
lord.
obliged.
My lord, I paid for listing of 2 matters, my lord, on 18 for admission. Relating to admission of PH course. So earlier there is the order. But not the final.
Matters of which year?
My lord, the 24 years. My lord, last this one, my lord, 24 matter.
No, matter of which year?
24. my lord.
24. Last listed when?
That was listed on my lord 10, 12, 9, my lord.
Last year.
Yes, my lord.
Okay, we can have it on Monday next.
On 18, my lord.
18 we have fixed many matters. Have it on Monday next. Monday will be you're on 18th. Okay, 18 July. Okay.
Must hold.
18 June. Okay. Yes, instructions.
Now, look at the Assam State School Board has to correct this and
My lord, this was
I have
copy
served a copy to-
yesterday, my lord. My lord, here, my lord, the instruction is required.
No, they have, we had directed Mr. Bhuya to have the instructions. The officer, director of higher education has very fairly and balancing the equity said one post, one rather seat can be kept vacant for on spot admission, which is scheduled on 28th to 24th.
That is the spot
Admission,
admission.
yes.
And if I may request your worship, that at least the 20 marks may be uploaded, your lordship, because
That has been already been done by the
Sir,
college, by the
Your
school.
Lordship can see. I'll read this order. With reference to the subject cited above, I have the honor to inform that the admission into the undergraduate program for the academic session so and so is currently going on.
Hmm.
Through the summer admission portal. The admission
No,
process.
we have read this.
Yes, now, my lord, your lordship kindly see. The undersigned has gone through the facts and circumstances of the case.
Hmm.
Then, my lord, at this stage, this is important, my lord, at this stage, one seat may be kept for Kishore Das for spot admission at DC College, subject to the outcome of the results and availability of seat. Now, my lord, the results will have to be corrected by the respondent number, this council, respondent number 2. My lord, because in their portal, the wrong marks has been shown. Therefore, that will have to be corrected. If your
Now
lordship,
you keep a seat vacant.
yes, your lordship may direct them to correct it.
Okay.
And thereafter, my lord, we shall publish the result.
Okay.
After correction, within a day, we shall make.
Yes, okay. We'll keep this pending. We'll not dispose of,
yes, sir.
Yes, sir. Your lordship kindly.
because if we dispose of, matter will be,
Right.
okay. Pursuant to the order dated 6/6/2025, 3S Bhuya, learned standing council, higher education has placed before this court written instructions dated 9/6/2025, as per which a suggestion has been made that one seat for the candidate in question may be kept vacant subject to outcome of the results and availability of seats. One seat for the candidate in the GC college, লেখা দিয়েছে, হ্যাঁ? Full stop, para. Sri D.K. Roy, Learned Council, Standing Council. What do you call? ASSCB.
ASSCB.
ASSCB is also present today. Full stop. In view of the aforesaid instructions and taking into consideration the facts and circumstances, it is directed, it is directed that the respondent GC college shall keep one seat vacant subject to the results and availability of seats. Full stop. Subject to the results. Don't say availability of seats. Have you uploaded in the meantime?
They are not
My
uploaded.
lord, actually, respond number 2.
No, from the college.
No, but after the correction only.
The ASSCB represented by Sri Roy is directed to look into the matter.
Yes.
And upload the corrected results with utmost urgency. And thereafter, the college authorities to take consequential action so that the the candidate in question does not lose a year. Full stop. List when?
Just before the spot admission, if your lordship, because
We'll have it from 28th it starts. We'll have it on 19th
yes, your lordship.
or not 19th. 19th will be too narrow. On 18th. No, 19th is okay. 19th.
19th, you know.
19th.
If the correction can be made within 2 days, but we can.
We said with utmost urgency, have said.
Right.
Let a copy of the writ petition be served by Sri Biswas to by Sri Biswas, the learned counsel for the petitioner, to Sri Roy, to
We have
enable
served
him.
the copy.
One copy, sir.
One copy, so I can serve another copy.
No, it's to enable him to obtain the instructions. Further, let a copy of this order be furnished to Sri Roy during the course of the day. We'll give it to you. Collect it from a court master.
Yes, sir.
Obliged.
Highly obliged.
Copy of the written instructions dated 9/6/2025 is made part of records.
Obliged.
May I please, your lordship?
Yes,
Earlier occasion,
yes.
respondent to directed to obtain instruction regarding my representation submitted to the.
For condonation of age.
My lord, my-
Yes.
I have received certain instruction.
What is it? Now, why is a cabinet approval required?
The second page is also there, madam, the for
Hmm?
the secretary, madam.
What is second? Secretary.
Second page also says.
I am directing on
The procedural.
Okay, I think it's on the right direction. When are the exams, Mr. Hendy?
Well, 15 June, next 15 June.
15 June, you don't have much time.
Yes, ma'am. Otherwise, madam, after 1951 OM, my lord. Secretary has power. The last advertisement,
Now, why is the cabinet approval required? Is it required?
well, in the earlier, last year advertisement, and that was not the procedure, my lord. Directly, secretary has approved for that application.
But suppose, see, in principle, you have said that you have to abide. It's a notification.
It's kind of a vague, my lord.
No, but if you take a decision not to condone the age,
Yes, yes.
matter is different. They are out. But if you agree to condone their age, and in the meantime, the last date is over, what fruits will they get of this litigation
Yes,
if they are
that-
successful?
Purpose is not served, my lord. Purpose-
And when is the cabinet sitting, that you cannot say with certainty? So how do you resolve this matter?
Till the disposal, this the process will be still.
Process we cannot stay. You allow them to participate. That will be subject to the outcome. Okay.
The only thing is, my lord, now I think it's all are in online mode, my lord. So, if this age is not condoned, then, cannot enter.
But for that, they cannot suffer loss.
Yes, yes, yes. My lord may pass the order, my lord, that will,
Okay.
accordingly.
Heard. Your Hendik. M. Hendik.
My lord.
Heard Sri M. Hendik, Learned Counsel for the more than one petitioner.
This one,
Petitioners, how many of them?
two petitions. Put this one, my lord.
For the petitioners who have approached this court regarding their candidature in a recruitment process Full stop. It is the case of the petitioners that they were appointed as part-time assistant professor in the Assam Engineering College, Guwahati, initially for 4 months in the years 2018 and 2021 respectively. And such appointments were extended from time to time. Full stop. Subsequently, on 21/1/2025, the petitioners were appointed as assistant professor under regulation 3 within bracket small f of the APSC within bracket regulation of so and so function so and so. Thereafter, an advertisement has been issued on 2/4/2025 for filling up some vacant post of assistant professor in the state engineering colleges under the higher within bracket technical education department. However, the petitioners have faced predicament in applying for the same as they are overaged as on 1/1/2025. Accordingly, the petitioners had submitted representations for condonation of age. However, the same was not considered, and therefore the petitioners had preferred WPC 2239/2025, and this court had directed consideration of the representations submitted by the petitioners, which has not been done, leading to filing of contempt case 285 of 2025. Full stop. But did you apply in the, did you participate in a written test?
No, my lord.
But OMR has already been published.
No, my lord. OMR, that OMR test, my lord.
Test, the date of written test has been
Written test, my
published.
lord. OMR was written test, that, my lord.
On 15/6.
My lord.
Yes, because of
In the
non-conduct.
meantime, a notification has been issued on 3/6/2025 fixing the OMR-MCQ based written test on 15/6/2025. Tara? When this matter was moved on 6/6/2025, this court had passed the following order, 6/6/2025. Quote kar dijiye. Tara? 3 Das, the Learned Standing Council, Higher Education Department, has placed before this court written instructions dated 9/6/2025 with an enclosure of a communication dated 8/4/2025, from where it appears that the Higher Education Department has agreed to consider the age condemnation in principle. Full stop. It further appears from the instructions that the approval of the state cabinet has been sought for. Para? Considering the above, that notice be issued, returnable by 4 weeks. 3 Das, Learned Standing Council, Higher Education Department accepts notice on behalf of 1 to 3.
1, 2, 3, my lord.
4 is the Engineering Service
Four is,
Recruitment
my
Board.
lord, Mr. K. Kukui will tell
Who?
appear.
K
Mr.
go.
K. Kukui, it's an appear for the-
Okay. 1 to 3. 4. K go is he in the court?
Yes, ma'am.
He appears as what? He appears in what capacity?
My lord. Standing council, ma'am.
Standing Council of what?
Yes.
Technical or what?
He is also a standing counsel of higher education, my lord, but for engineering recruitment service board, my lord, he
Okay,
appears.
for the response number, okay, Google. For response number 4, let extra copies be served upon them. Para. Heard the learned counsel on the interim prayer. Para. Balancing the equities and also taking into consideration the written instructions as per which the higher education department has agreed in principle regarding the consideration of the cases of the petitioner for age condemnation, it is provided that in the OMR test scheduled on 13,
15,
on
15,
15,
2025.
15/6/2025, the petitioners would be allowed to participate, full stop. Since this court has been informed that the mode adopted is online, the department would make facilities to enable the petitioners to appear in the said test, full stop. It is however made clear that such appearance would be would not vest any right to claim appointment and would be subject to final orders that may be passed by this court as well as the consequential orders that may be passed by the department. First, you allow them to appear. Written instructions dated 9/6/2025 are made part of the records. Para, let a copy of this order be furnished to Sri Das during the course of the day.
Petitioner will also approach. I'll inform them.
We are giving you the copy.
Okay.
You also make the
Mind. Obliged.
the petitioners will render necessary cooperation to for implementation of the order passed today.
Today, appointment in the higher education department is not allowed. As the certificate hearing of honor. That's all. Today,
I'll
He'll facilitate.
Yes. Mind.
Okay, next.
Item 2.
Yes, what is this, Mr. Chaudhary?
Matter pertains to not providing salary at the ROP prescribed rate. Lordship, petitioner, there are 3 petitioner lordship. Petitioner 2 already expired lordship. I have already implemented substituted the legal errors lordship.
Mr. Bora, you have filed affidavit.
Yes, sir.
Can we take it up for disposal today?
These 3 petition,
There are 3 petitioners.
3 petitioner lordship. Petitioner number 2 is already expired lordship. I have substituted the legal error.
Yes.
These 3 petitioners lordship, they were engaged as grade 4 staff on daily wage basis in our earlier DPEP, District Elementary Education Program.
District
In a-
Elementary Education,
Program,
DEEP.
DPEP. District Primary Education Program. District Primary Education, DPEP.
District. Appointed as grade 4.
Grade 4 on daily wage basis.
Yes.
Annexure 1, 2, 3 are the appointment letters, lordship.
Hmm. Page, Page,
Page number 16, Lordship.
when was it?
It was 22nd February 1999, Lordship.
Okay.
And petitioner number was appointed on 22nd of February 1991. Petitioner number 2 was appointed on 19th of March 1999.
Hmm.
And petitioner number 3 on 6/1/1999.
Okay.
From 30th of June 2023, this scheme, the PEP, was closed, Lordship. And from 1st of July 2003, there was a new scheme introduced, that is Sarva Shiksha Abhijan Mission.
Yes.
On the introduction of Sarva Shiksha Abhijan Mission, Lordship, these 3 petitioners were sought to be terminated from their service. At the same time, Lordship, respondent number 4, he was also contemporaneous grade 4 daily wage employee who was also appointed in erstwhile DPEP, Lordship.
Hmm.
But he was automatically absorbed in newly introduced Sarva Shiksha Abhijan Mission, Lordship.
Hmm.
So these 3 petitioners pursued the matters along with similarly situated other person, Lordship. On their persuasion, they have been initially asked to work in Sarva Shiksha Abhijan Mission as contingent manual labor. And later on, they were
As
directed
contingent?
contingent manual labor, Lordship.
Okay.
But later on, they were directed to work as night chowkidar, Lordship, in Sarva Shiksha Abhijan Mission. If your Lordship come to page number 24, Annex 7,
Hmm. Yes, 24.
24, Annex 7, third paragraph, Lordship. This is the objective. This letter was 15th of July 2002, that is just before closure of the DPEP, Lordship. The services of the contingent labor will be utilized as office peon at the concerned BRCC offices, replacing the present grade 4 employee to the night chowkidar. The petitioners were working as grade 4 employee, so they were replaced to work as night
No,
chowkidar.
but this is to 2002.
2002.
You had said that the scheme, earlier scheme closed down on
This-
31/6/2003.
This was when the transition period was going on. That time this decision was taken.
What was this decision?
To replace the grade 4 employee to night chowkidar, Lordship.
To convert. Convert.
Convert, Lordship.
Replace or convert?
Replace to Lordship, kindly come to paragraph number 3. The services of the contingent labor will be utilized as office peon at the concerned BRCC offices, replacing the present grade 4 employee to night chowkidar. So instead of grade 4 employee, they will be working as night chowkidar.
No, no. Services of the contingent labor will be utilized as office peon. As so and so, replacing the present grade 4 employee to the existing grade 4 employees would be shifted as night chowkidar,
Night
and in
chowkidar.
their place, contingent laborers would be used as office peons. That
Office
is the
peon.
meaning.
Yes, Lordship.
You were contingent labor.
At that time, Lordship, when the decision was taken, I was grade 4 employee daily wage basis. This is because this is 2002 letter, Lordship. In July, 1st of July 2003 only, Sarva Shiksha Abhijan Mission started, Lordship.
But in your chronology of facts, you have not put in the correct order. You said
Yes, Lordship.
that scheme was closed on 31/6/2003.
Lordship.
Then SSA mission was introduced. You persuaded. R4 was automatically
Yes,
absorbed.
according to this, I should have been allowed to work as night chowkidar from the 1st of July 2003 itself, but instead they have asked me to work as contingent laborer. Later on, Lordship, they have asked me to directed me to work as night chowkidar, Lordship. But this petition, respondent number 7 at page number 28 was who was appointed on 12th of 18th of February 2000 to 1999 Lordship, Annexa 8, page number 28.
Yes.
You are hereby appointed as grade 4 in BRC so and so joining basis, daily wage basis.
Nipen Thakuria is who? R7.
No, the respondent number 4 Lordship.
Nipen Thakuria.
Respondent number 4 Nipen Thakuria Lordship.
R4.
Yes, Lordship. He was also allowed to work as grade 4 staff in DPEP, but at the end of when the Sarva Shiksha Vision mission started, he was directly asked to work as night chowkidar Lordship.
Yes. Now what is your grievance? You are
Lordship-
not been allowed to work as night chowkidar.
Yes, Lordship. No, Lordship. There was some discussion was going on between the authorities and the petitioners and similarly situated person. And after that, they have come to a decision at page number 31, Lordship.
Hmm.
Point number 1. The revision of salary of SSA employees on the basis of ROP 2010 by bringing post-to-post equivalence of SSA contractual employees with the state government employees on the basis of qualification and nature of job and considering the length of services from DPEP SSA will be implemented with effect from January 2012.
Hmm.
So they have decided to give ROP prescribed rate, salary at the ROP prescribed rate. And
This is dated what? This is dated what? 31?
this
31?
that meeting was conducted, the meeting was at the office number of 16/3/2012. First paragraph. But after this decision, Lordship, they have given salary at the ROP prescribed rate to the respondent number 4, but they have not given the salary at the ROP prescribed rate to the petitioner, Lordship.
Okay. Who is appearing for the SP number 4? R4, anybody is appearing?
No.
R4 has been served.
Therefore, he has not appeared, Lordship.
Served.
Served, Lord.
Which order?
Order, I
You deemed to be served. 7/9. 7/9/2022. Okay.
Lordship, I do not have exact order that the respondent number 4 was directed to work as night chowkidar, but in the year 2008, he was terminated from service, Lordship. So he approached this honorable court for reinstatement, and this honorable court had directed to reinstate that respondent number 7, and accordingly, he has been reinstated, Lordship. I have annexed the order of the bail order, Lordship, that passing order, Lordship, in page number 37, Lordship. It
What?
is
Passing of termination.
passing of termination, Lordship, and accordingly it was passed, Lordship, directed to be reinstated and accordingly reinstated also. Paragraph number 36, page number 36, annex 13, Lordship. Last paragraph, Lordship. An advertisement filling grade 4 post in the office of the block regional coordinator Bajali under DPP was issued, and consequent thereupon the petitioner being eligible applied for the post and get selected. Accordingly, he was engaged as grade 4 employee in the office of the regional coordinator Bajali on daily wages basis 48 rupees per day.
What is the repetition number?
Repetition number, Lordship, that Lordship will get repetition number at 975 1067 of 2010, Lordship.
Where is the first page of the order?
First page is not there, Lordship.
Why?
But Lordship can kindly come to page number 42, Lordship. Subsequently, this order, Lordship, he has been reinstated, Lordship. This is the notification of reinstatement. There, the writ petition number is there, 1067 of 2010. So in this order, Lordship, it was mentioned that he was directed to work as night chowkidar after introduction of the Sarva Shiksha Abhijan mission, Lord.
Order is of 2010.
Or
The High
yes,
Court order
19/7/2010.
and this consequential order is of 2001.
Writ appeal was also filed, Lordship, thereafter. Writ appeal number is also there, Lord. Writ appeal number 358 of 2014, Lord.
Accommodated as grade 4.
He has worked
R
as
four- R4.
night chowkidar, gate 4, Lord.
The respondent number 4.
4, Lordship. Lordship, one proposal also submitted for providing ROP prescribed rate to the petitioner, Lordship. That is in my affidavit in reply at page number 86, Lordship.
Yep. 86.
86, Lord. Proposal for providing ROP based salary to the block night chowkidar, Lordship. May I read this page, Lordship?
Please read.
This proposal was sent on 2nd of February 2021, Lordship. Block Mission Office BMC is the most important management structure of SSA at the first level. Field level and proper implementation of SSA activities depend on the proper functioning of BMC office. It has second paragraph. It has been felt that there is a need for engagement of chowkidar for each block mission office to guard the valuable assets of the office from stealing, pilferage, etc. There are 140 numbers of SSA blocks in Assam, where one night chowkidar in each block mission office, and as per decision of 7 EC meeting of SSA Assam block, night chowkidars for each 145 numbers block mission office have been engaged formally on the basis of necessity need based for safeguard and security of the concerned office. Even some of them were engaged in Arstal DPEB period also. At present, 130 numbers of block night chowkidars are working. Most of them have been utilized in their works also. As per their qualification and experience, they have been paid 4,500 initially. Now they are getting 900 rupees per seat. Now they pray to incorporate their post in SR and FR and enhance their monthly salary equal to the other grade 4 staff of SSA along with CPF benefit, referring the judgment of Honorable Supreme Court equal pay for equal work. At present, their remuneration is being given 6,500. The details of the statement for getting ROP based salary as mentioned below. So if this ROP based salary is given, the monthly remuneration will be 19,402, Lordship. After this proposal was sent, it was directed to place before the executive committee, Lordship. At page number 89, Lordship. With reference to the letter on the subject cited above, I am directed to request you kindly to place the matter before the EC. And thereafter a
Page
decision
number?
was taken.
Page
Page number 89, Lordship.
89.
And thereafter a decision was taken, and accordingly, in pursuance, page number 90, Lordship, Annex 7, in pursuance of the approval of 10th Executive Committee meeting of Samagra Shiksha Abhijan held on 13/4/2023, the monthly wages of block night chowkidar is hereby enhanced and fixed at rupees 9,000. So at present, they are getting 9,000 per month, Lordship. Lordship, I have preferred an RT application, and from that the present pay structure of Nipen Thakuria, that is respondent number 4, we have obtained. At my repetition, Lordship, an exact 10 page 30.
30.
30, Lordship. This is the present pay scale of Nipen Thakuria as follows. He is getting a net pay of 21,062 rupees, whereas the petitioners are getting mere 9,000 rupees.
Okay.
The contention of the respondent SSA in their as per their affidavit, Lordship, at paragraph number 10 of internal pay 49, that meeting, that meeting where the ROP prescribed rate was supposed to be given, that was related to contractual employee under SSA and not for daily wages. This is their contention.
Yes.
So my prayer is to provide the ROP prescribed rate to the petitioner also. Since to respondent petitioner number 2 expired, Lordship, so his any benefits if your Lordship provided, then that will be given to the legal heirs.
Yes, Mr. Bora.
There are two affidavit filed by the SSA, madam. So affidavit, madam, that is, it start from page number 46, my lord.
No, is the claim based on a foundation of discrimination, qua R4, or is it independently based on the decision of the SSA?
Intention is that there is a discrimination that the private respondents are appointed and they were taken in that they are not equally treated as the private. In fact, the private respondents, they are separate things, they are in a scheme, a daily wage, whereas the other respondents are from contractual employment. And in fact, in regard to paragraph respondent number 5, these
No, that is the reason we are asking you. Is the claim based on the foundation of discrimination, which will require them to establish that they are similarly placed, equally placed as R4,
R4,
only then they can claim a case of
similarly,
discrimination. But if you can make out a case that they are a different class and R4 belongs to a different class,
Yes.
so benefits given to R4 cannot automatically be given to them, number one. If that is the foundation, matter will be different. If otherwise they are making out a case that based on your decision, they should also be given the benefit irrespective of what you have given to R4. That is also cited as an example. But they, on their own, are also entitled to get the ROP benefits. Is it that a case, or is it a case of discrimination?
R4 and R5 is completely different. R4 and 5 are from the contractual employee, whereas these are the under the scheme.
No, this submission of yours, you can make, if we accept the first point, that it is only based on discrimination, that if you are giving to R4, R5, you give it to us also. Then you can say that no, R4, R5, say, they constitute a separate class. You cannot be equated.
And
But if there is any foundation that the claim is based on your decision to give certain benefits of ROP, they are also entitled, then the case may be different. But I don't think Mr. Chaudhary has developed that case in that manner. He is only citing discrimination.
Discrimination, and in that discrimination, my lord, it is that they were daily wage earners. That scheme has come to an end. Thereafter, my lord, respondent of
R4 is a contractual employee.
R4, R5 contractually. In respect of
There is R5 also.
R5 also. There was a
Who is R5?
R5 was after termination of our respondent number 4, Lordship, he was engaged in that post.
R5 in a document directed must to file a separate affidavit etc. to R5 that how he has communicated that particular post, my lord. An additional affidavit was filed, my lord. They are all interview their teams how his appointment.
You
was
say
made.
that R4 and R5 are contractual,
Contractual
and this petitioner
It's daily wage earner under a scheme that has come to an end. Since they were not in the senior most, they were not taken in the subsequently the SSA has come into existence. And in respect to R5, my lord, I have filed additional affidavit in the court.
But nonetheless, you have ultimately absorbed him in SSA.
The contextual basis in respect of after contextual basis in respect to R5, advertisement was issued.
No, for the petitioners, they are still working.
No,
Working, Lord. They are working as night petitioners, Lord.
Yes, petitioners.
but their petitioners,
Only then they can claim ROP. Otherwise, if they are not in job, how do they claim?
team has completed complaint in my lord. I will that I need to take instruction on that if they are working, but my instruction was that they were not working.
Are you working, Mr. Chaudhary?
Yes, Lord. Okay, respond petitioner number 2 expired, Lordship.
No,
And
that
there
is
four-
okay.
yes.
But 1 and 2, 1 and 3?
Yes, 1 and 3 are working, Lord.
Well, I will get then I have to get the instruction. My instruction was
Oh,
that
that is the basic thing. If they are not working, they would have asked for arrears. They are not asking only for arrears. They are also asking ROP benefits.
if they are working, my lord, there is a scheme. As per that ROP, they will get it because there is already a notification and all the person in the SS are getting it.
This you should have told at the beginning. We had given you so much of time. But when can you get back?
Well, after a week, my lord.
Monday next.
Lord.
Monday next. Hearts free, Eddie Chaudhary, Leonard Counts. Good group. I said.
Page 27 is the initial appointment order. Restaurant number 4.
এইফালে আহিব দিব লাগে দৌৰি থাকিলে ঘূৰি ইহঁতে হ'ব নেকি Heard Sri Eddie Chaudhary, Learned Counsel for the petitioners. Also heard Sri S. Bora, Learned Standing Counsel, Assistant. Full stop. After considering the matter after narration of the facts by the learned counsel for the petitioner, Sri Bora, the learned standing counsel SSA, has submitted that he was under the impression that the petitioners are not presently in service. Full stop. He accordingly prays for some time to obtain specific instructions in this regard. Para, considering that this matter is pending since the year 2019, a small accommodation, 19, let the matter be listed
On
on
70.
Monday next or Tuesday next.
Tuesday next.
Tuesday next.
What will be part of it? What will be part of
It will come before this bench, Tuesday next.
Avla is not.
Is there lost? They lost it.
kindly peruse the last order dated 4/3/2025, my lord.
Yes. 4/3.
Yes, my lord.
Yes, instruction, Mr. Das.
Records were called for, my lord. And after that, on 4 occasions, the respondents have sought for time to produce records, my lord. Records have not been.
Yes.
But records are there, my lord. In fact, on last occasion, Justice Jamil has already had part of. But my lord can have. There is records are there. Actually, what happened, the original records are, my lord,
Now, did you hold any departmental proceeding?
my lord, I'll be fair, my lord, but there is no,
You have to be fair. You did not say that you
yes,
need to be
yes,
fair.
yes, my lord.
We expect that you are fair in all the submissions.
Proper-
You cannot be
proper-
unfair in some,
This
fair in some.
First notice is not, my lord, by the,
Let's see.
by the department, but proper served by the college of.
Now, thereafter, what happened? Did you follow the procedure?
Procedural lapses.
Is there any inquiry report in your writ petition?
Yes, my lord.
Inquiry report is
Yeah,
there. What have
inquiry-
you alleged in your petition?
Allegations, my lord.
What have you alleged in your petition? What are your grounds?
In my petition, my lord, I have stated that I was not given an opportunity, my lord, to cross-examine, or I was not given any opportunity to appoint presenting officer. And
Presenting officer you will
and
appoint.
above all, my lord, above
You will
all,
not
my
appoint
lord,
presenting officer. It's a
Above all,
prerogative
my
of the
lord.
management.
Yes, my lord. In fact, I have stated in my reply that I was suffering from mental illness. I have submitted medical documents also, my lord, and it is reflected in the inquiry report also that during that period I was suffering from mental illness, and because of this, my lord, I was not, my lord.
Madam, those are on the merits. We are on the procedural aspect.
Proceed.
We'll only examine whether the decision-making process is proper or not.
But
Was an inquiry held? It was held. Number two, were you given show cause notice you were given.
show cause notice, yes, my lord, during department.
So what are your grounds of challenge?
Grounds of challenge means here only disproportionate punishment. Only limited prayer is there, my lord, because
Disproportionate
your
pun-
lordship may kindly see the allegations.
Yes, what are the allegations?
Allegations are, my lord, that I was, my lord, at page 23, my lord.
2-3.
Page 20, yes, my lord, annexure E, my lord.
23.
Yes, my lord, the charges and allegations, you are very unenthusiastic in taking your classes. You don't explain clearly and properly about the syllabus topics. You are very irregular in attending your classes, though you put your signature on the class register but left the classroom without any class. You used to come to your department very late, and sometimes after taking the attendance of the student, you left the classroom without giving any lecture. You are very non-cooperative with the departmental activities.
Madam, you have gone one
All
step.
this, because of this, yes, my lord.
Madam, you have gone one step further. You are reading the inquiry report. We want to see what are the allegations against you. Where is
Yes,
the charge?
same allegation.
Where?
Inquiry report is,
Oh, no, we don't run the inquiry
yes, my
report.
lord. Inquiry report is annexure E, my lord.
That we have seen, paragraph 23.
Yes, my,
What are your charges?
and the last, these are the charges, my lord.
Where do you get these charges?
Inquiry report, annexure E, my lord. Charges are there, my lord.
Madam, why don't you understand the question? We have seen what is written in the
Yes,
inquiry
my lord.
report. We want the charge memo. Where is the charge?
Yes, it is there.
What is your reply there to?
Yes, my lord. My reply is there.
First, let us see the
Annexure
charges.
D, my lord.
Let us see the charges.
Annexure D, my lord. I have replied, my lord. Annexure D. May I read my reply, my lord? I was interested in annexure D, page 18, my lord. I was interested in taking classes and explain properly with the best of my ability. I taught clearly and properly as per syllabus topic. During my tenure of work in one semester, 7 students got first class. I attended classes regularly and did not leave the classes and college without completing.
Madam, you have a case. You are not being able to project your case, unfortunately.
Here,
What is this reply? This is reply to the inquiry report.
inquiry.
We want your reply to the show cause. Where is the show cause?
This is the reply, my lord. No other replies
This is
are there.
reply to the inquiry report's finding.
After
Where is the show cause?
only one show cause notice
Which
was
one?
there.
Page?
Show cause notice at page. Annexure C, my lord, at page 15.
We have read this, Mr.
Yes,
Das.
only this one, nothing else, my lord.
Is,
No other notices
is page
were there.
15 the only show cause?
Page 50, my lord.
Only this one, my lord. No notice was there, my lord. Then he filed reply and then inquiry was held and inquiry report was submitted.
Where is the
As-
initiation of the proceeding?
My lord, as per my affidavit, my lord, the stand of the department is that the principal has issued a show cause.
Where?
1/1/2016, my lord, para 5 of my affidavit.
No, where? Let us see the show cause. Where?
My lord, show cause is not annexed along with the affidavit.
Then show us in
In
the.
fact, the show cause is not there in the record.
Then. Have you checked the records?
Yes, but I have checked. That was not there. He has been an inquiry was held, my lord, but then
Mr. Das, there is a procedure
Yes, yes.
laid down in the 1964 rules, irrespective of the rules. Department proceeding, it's not a new thing.
Yes.
If there are any allegations, you put the allegations to the delinquent, solicit his response.
Yes.
If you are satisfied with the response, you close it.
Yes.
If you are not satisfied, then you say that we'll have to inquire because we are not satisfied with your reply. How do you inquire? You have a disciplinary proceeding where you appoint an inquiry officer, a presenting officer. They will sit, hold an inquiry, give him a chance. Inquiry officer gives a report either in favor of the allegation or saying that allegations are not proved, depending on which you will take subsequent calls in accordance with law. Now here the show cause notice is not there. It appears that the inquiry committee has framed certain charges. Where do they get the power? Inquiry committee is not the disciplinary authority.
as per record, there is no procedural step there.
What is the penalty order removal?
Penalty order, my lord, that is,
It's released from service.
annexure F, my lord, page 31 and 32. Page 31, your lordship may kindly see the last para, my lord. The inquiry committee observed that the
No, no,
allegation.
16/1/2017, there is a show cause. Because you have referred to page 148C of this file. What is this? 148C? Kindly see, Mr. Das,
Yes, my lord.
page 31.
In 1/2007.
Page 31.
This I have annexed as annexure, my lord. Annexure 15.
Come to page 31, Mr. Das, annexure F. Have you got a copy of the writ petition?
Yes, yes.
Annexure F,
This is the
order-
order, my lord.
order dated 26/12/2017.
Yes, ma'am.
Yes, kindly come to the third paragraph.
The college authority, ma'am.
College, yes, please read.
This was issued
College
by the
authority
college
issued-
authority, ma'am.
The college authority issued a show cause to him, white letter to the student, which is at page number.
148C
148C
of this file. Where is 148C?
Hello?
There will be some order.
Yes, my lord. In fact, in our affidavit also,
You just now have said this same date, 16/1/2017, in your affidavit. Same date.
yes, ma'am.
But where is that?
Actually, the record, what had happened, they misplaced the record, they, then thereafter, it was reconstructed, ma'am. If my lord sees the initial letter of the record, my lord, the record got misplaced, then it was reconstructed.
And my lord, here departmental proceeding was not done by the disciplinary authority or appointing authority, my lord. It was done by the college authority, who is not the appointing authority, my lord. And only on the basis of the report of the college authority, the removal order has been issued by the director, my lord.
Removal is by the director. There is no dispute with this.
Yes, my lord,
Director.
but the inquiry was held by the principal, by the college authority, my lord. And the inquiry committee also constituted of the principal and the vice principal.
This is the letter of 16/1/2017, written by the principal to the petitioner.
Is the principal the appointing authority? I think there is a flaw in this.
But-
The foundation is not correct.
If the appointing authority delegates the power, then he is the power.
Delegate also will be a problem. Appointing authority can constitute an inquiry committee or inquiry officer. cannot powers of appointment, powers of dismissal cannot be delegated.
I found a judgment actually where says that
No, delegation can be done for things which does not ultimately culminate to something which causes prejudice. Procedural aspect, yes. You can, that is why there is a provision of having a presenting officer, an inquiry officer. If you read the 1964 rules, if the disciplinary authority, he can himself do the inquiry. If he chooses that the inquiry should be done by somebody else, he can appoint an inquiry officer. The director could have appointed an inquiry officer. Initiation, the very initiation of issuing the show cause is not done by the director. Cannot be sustained.
in fact this letter doesn't seem like a supposed.
Hmm?
This letter doesn't seem like a supposed.
No, we are not on the contents or the format of the letter. Issuing authority. That is more important for us. You are correct in contending that this is not, it does not conform to the requirement 64 rules. It has to be, the charges have to be definite. It has to be accompanied with a statement of allegation. There has to be a list of documents, list of witnesses, and thereafter solicit his response.
My lord, my this with this regard, but my submission is
See, the format is not very correct, but contents are more or less there. You see the second part, source of allegation. These are the documents.
Yes, sir.
A complaint, report, and report. These are documents.
Yes, sir.
And the first part are the charges.
Yes.
So it may not be in the exact format which is prescribed by law, but we can, there may not be a substantial flaw with this. But the flaw is with the person who has issued this.
My in this prescription, my humble submission would be only two submissions, my lord. First is, my lord, since there is a alternative remedy for appeal, my lord, then
No, the jurisdictional error. Why should we now relegate the petitioner to alternative remedy? The
no, my lord,
foundational error is there.
since there is a provision in the statute itself, so before coming to
It was not even started by the appropriate authority.
but
And
that the appellate authority has power to decide this aspect also, my lord. So I will rely on only one judgment, my lord. My lord, kindly
this
appreciate
is
this.
writ petition is of which year?
Of 2019, madam.
19 after 5 years, 6 years, we are not good.
And
No,
another,
this will be utter injustice.
but and
Sorry. Don't make this something. Make it an appropriate.
another
Yes.
submission would be, my lord. If there is a procedural lapses, my lord, say if there is a procedural lapses in the departmental proceeding, then also, my lord, a judgment says that, my lord, the petitioner cannot be reinstated. Rather, the court shall, my lord, court has to direct the authority to conduct the inquiry from that point where
Now, what is the point here? What is the point here of the procedural Let us not use the expression illegality. Let us use irregularity.
Yes.
When is the stage?
my lord, stage is so close, my lord.
Yes. Stage is so called. That is not even the stage. It is the foundation. At times we find that the report of the
college, then
that is not even the stage. It has not started. Foundation.
liberty, then, my lord,
Yeah, of course.
given
Of course, you in accordance with law. That you have.
my lord,
that you have.
then I can submit this judgment, my lord.
But madam, you have not structured your petition properly. We have to really make some
By somebody.
study on your papers to make out what case you are trying to portray.
I have, my lord, submitted written argument also, madam.
That will
It
be
is
more
there.
confusing it
It
seems.
is
Let
there,
us
my
see
lord.
what are your written arguments. It should not be more confusing than your oral arguments.
It is
My lord, last page, my lord, last page. subpara 16, 6.2 and 7. 16 says it is a settled proposition of law, settled legal proposition that once the court set aside an order of punishment on the ground that the inquiry was not properly conducted, the court cannot reinstate the employee. It must limit the case concerned to the disciplinary authority or for it to conduct the inquiry.
लिखा
The last occasion I have furnished one judgment, it is there in the record, sir, in support of my case.
Girish Bhushan.
Yes.
Which one? Girish Bhushan.
Yes. This is regarding disproportionate treatment. One coordinate benches order is there.
Oh. The validity and legality of an order dated 19/7/2016 issued by the Director of Higher Education Assam, by which the petitioner has been removed from service (19/7) 26/12, huh?
26/12.
26/12 is the subject matter of challenge. Full stop. The said order was followed by an order dated 30/12/2017 issued by the principal of the concerned college releasing the petitioner from service. Full stop. Para. As per the facts projected, the petitioner was serving as an assistant professor, comma, Department of Physics, comma, Gorgaon College, in the district of Hibahagar. Please have your seat. While in service, comma, the petitioner was served with a notice dated 16/1/2017, whereby he was informed regarding his suspension from service with immediate effect as per order passed by the Director of Higher Education. Full stop. The petitioner was also directed to show cause under Rule 9 of the Assam Service within bracket Discipline and Appeal bracket close rules 1964, read with Article 311 of the Constitution of India, as to why the penalties prescribed in the said rules should not be inflicted upon him. Full stop. The notice had contained 5 number of charges and 9 number of source of allegations. Full stop. It appears that the petitioner had shown cause, and thereafter an inquiry committee was constituted of 3 members, headed by, amongst whom one was the chairman. Full stop. The inquiry committee had conducted proceedings and thereafter had submitted a report full stop. The said report was forwarded by the Director of Higher Education, wide communication dated 21/10/2017 to the petitioner to seek his response. Full stop. For ready reference, the operative part of the communication dated 21/10/2017 is extracted herein below, page 16, last paragraph. Wrong amount force. Page 16. The petitioner had accordingly submitted his response via communication dated 16/11/2017, wherein he had also hinted upon his ailment. Full stop. However, vide the impugned order dated 26/12/2017, the petitioner has been removed from service with immediate effect. Full stop. I have heard Ms. S.B. Chaudhary, learned counsel for the petitioner. I have also heard Sri S. Das, learned standing counsel, Higher Education Department, who has also furnished certain records from the department. Para. The petitioner has structured the present challenge both on the grounds of procedural illegality and disproportionate punishment. Full stop. It has been contended by Ms. Chaudhary, the learned counsel, that the appointing authority, who is the disciplinary authority, he has submitted that the disciplinary authority cannot be an officer subordinate to the appointing authority. Full stop. In the instant case, the petitioner was holding the post of assistant professor who was appointed by the Director of Higher Education, and therefore the initiation of the proceeding vide a show cause notice issued by the principal is non-est in law. Full stop. She has submitted that though the suspension order was passed by the Director of Higher Education, the show cause notice could not have been issued by any authority subordinate to the disciplinary authority. Full stop. She has also submitted that in the disciplinary proceeding, which was conducted by a 3-member committee, there was gross violation of the principles of natural justice, inasmuch as the petitioner was not afforded any defense representative. Full stop. It is also contended that the response made by the petitioner were not taken were not given due consideration. Full stop. The learned counsel for the petitioner has also assailed the penalty on the grounds of disproportionality. Full stop. It is submitted that the charges were of minor nature, whereas a major penalty of removal from service has been passed, which is grossly disproportionate, and therefore interference of this court is called for. Full stop. Para. In support of our submissions, comma, the learned counsel for the petitioner has relied upon the case of Girish Bhushan Goel versus ... reported in 2014 Silova 1 SCC 82. Full stop. In the said case, the Honorable Supreme Court has dealt with the aspect of proportionality / quantum of punishment vis-a-vis the nature of charges. Full stop. Para. Per contra, comma, Sri Das, the learned standing counsel, has submitted that the charges involved cannot be said to be minor in nature, as the same is directly connected with the nature of the job entrusted to the petitioner. Full stop. It is submitted that there were specific charges that the petitioner was very irregular in attending the classes and did not show enthusiasm. Full stop. It is also the charge that he was not cooperative with the departmental activities. Full stop. He has refuted that there has been any violation of the principles of natural justice in conduct of the disciplinary proceeding, as due opportunity was granted to the petitioner, which he fully availed of. Full stop. He has also submitted that all the
the advertisement for the post of page your lordship will kindly turn to page 34 first.
34.
34. The advertisement. Here I will point out.
What is
that
the issue? Once again, please.
basically, as your lordship, this petitioner who is otherwise eligible to
For?
participate in the interview for the post of assistant professor in the Department of Folklore, Guwahati University,
Post
was
of,
not called for the
post
interview.
of assistant professor.
Assistant professor in the Department of Folklore.
Guwahati University, Department of Folklore.
Folklore. He was not even called for the interview, and then ultimately we came to know that why he was not called, which is actually arbitrary and without any authority. That's why it is before your.
But the posts have been filled up.
It has been subsequently filled up, your lordship. Initially, it was not filled up.
No, what relief can we grant you?
There is a, your lordship, relief means your lordship, otherwise if it is found to be arbitrary, the process.
No, the advertisement was of the year 2020.
No, it was in the year 2018.
18.
And the selection process, but appointment was recently, I think, in 24. The. No, no,
There is
this-
another writ petition, my lord, that was disposed of for declaring the result. Accordingly, my lord, the private respondent has been appealed.
No, what we are just contemplating, we have not even heard you. Suppose you make out a case
Yes,
for interference. Will it be proper to at least after 4 years?
that is where your lordship, even I have thought about it, but the question is, if there is a arbitrariness or.
No, we can declare it to be arbitrary. Then what would be the
That's the
following
next.
consequential next cause next
That is what
step.
even I thought about.
It is
I have actually.
Academic interest now, since my lord,
No, it
she has
cannot be
already-
academic interest, but question is whether that can be interfered or not. I have actually gone through a few judgments where the court in a case, not a similar matter.
Is there any kind of observations made by this court earlier regarding any development?
No, with regard, his appointment was subject to the outcome of it.
There is an order.
There is an order.
You are not called for in the interview.
No, yes.
You are not called.
No. That is where the issue lies, your lordship. And second part, your lordship, when I will take your lordship to the case, my case, your lordship will see where the illegal. I'll just point them. I'll not take a long time in this. So I'll just point out the at page 34 is the epithet. This is on 12/6/2018. Page 34. This is the
Yes.
part, the main advertisement has many other posts. Only this part I have, this is the type of. Applications are invited from Indian citizens for teaching for the post of professor, assistant professor, assistant professor in various departments. Details of the advertisement are terms of the strength to strength. It is on 12/6. You will find the page 37 is with regard to this particular page 37. Here I am pointing out Department of Folklore Research. It's folklore research. Department of Folklore Research, not folklore alone. Then it is assistant professor. Now, specialization part is important. You will also kindly take that up. It is open, but desirable master of music and equivalent. And the minimum essential qualification is as per the UGC now. There is no dispute on that. It is as per the UGC. So basically, one thing, first point is that it is open and desirable in masters in music. The petitioner here in your lordship has is at page 23 for a moment. Your lordship will kindly go through that because that is very important. That is why I am pointing this out. Page 23 for us. This is the biodata. We have annexed the documents. I'm not going to each and every document. Just the biodata, I'll just point out 2-3 things. Page 23. Here, the biodata, your lordship will see the academic qualifications. Here, your lordship, HSLC is the second division. SSLC is first division. BA, second division. Cultural studies, second class. And MPhil in folklore, first class. This is the qualification. Subsequently, he has been awarded award of PhD degree. He was also awarded PhD degree, Your Lordship. And then, Your Lordship, he has also got in the next page 24, he's qualified in UGC net qualified. Next page. I have annexed those documents. I am not pointing it out. I'm just reading it from here. He's also net qualified as well as PhD. Then, Your Lordship, extra qualification. It is specifically indicated. He is a master in music, in Indian classical music, MMuse. Now, this is the desirable qualification which the petitioner has. That is why I'm pointing it out. Whereas this is not there in with regard to the private response.
Where is it? The master of?
That Your Lordship will find at page 24. Your Lordship will find page 24 in extra qualification.
Yes.
D. Masters in music. We have annexed the document. They're already in annexed here in page.
It doesn't matter. Oh, okay.
All these are annexed from page, I think 16 up. Sorry.
Your MUs.
ME. I've annexed the document. And this is not going through all the documents. That's why I just pointed
Yes,
it
yes,
out.
yes. Mm.
So I have measured second, Your Lordship. Teaching experience part is also there. He has served in the various, like Your Lordship, altogether about 5, 6 years, 7 years of teaching experience. He has given it in the next part. Served as faculty from so and so, 2.5 years here, 10 years teaching experience as an assistant professor in tourism and management. These are the experiences.
Okay.
So he has also had teaching experience. So I'll not go into all this, Your Lordship. Straight away, 2 things. Now he's Masters of Music. And now Your Lordship will kindly take up the affidavit filed by them. Now, otherwise, the eligibility, Your Lordship knows that he should be a 55 basic minimum marks in master's degree is the qualification required for a assistant professor. And along with that, he will have to have a net. If he is a net qualified, he'll have net qualified. And those having PhD, it's an additional qualification. Now, Your Lordship will kindly take up the affidavit filed by the university.
Yes. Where is the rejection?
There, Your Lordship, there's no rejection as such. I was not, because what has happened, the process is like that. When we apply, it goes to a cell called IQAC. So that cell, Your Lordship, goes to the all the applications and then select the persons concerned on the basis of what is placed before them. And then it was posed before the
The
selection.
rejected candidates are not communicated.
Nothing has been
Okay.
communicated. When I came to know.
The ones who are found eligible are called for.
Yes.
And the ones rejected will not be communicated.
No, nothing has been.
Okay.
In fact, in my case, it was not communicated.
Okay. Then we go to the affidavit.
Yes. Directly, I'm taking you also to the affidavit
Page?
because there are
Page?
many affidavits. First affidavit was filed. Was filed by the respondent 1, 2, 3, and 4.
Yes. Yes.
Yes, just a moment.
By Guwahati University.
But in here in this affidavit, just a moment. Another type 1. What you will see at para 4 of the affidavit.
Yes, please.
I'll just read that. They have given the ground for which mainly rejection part.
Yes, yes.
That with regard to the statement made in paragraph 22, while putting the writ petitioner's strictest proof thereof, the deponent respectfully begs to state that another there's altogether 30 numbers of candidates submitted application for the post of assistant professor in Department of Folklore Research, Guwahati, with specialization desirable strength. According to the set procedure, the applications were forwarded to the coordinator, internal quality assurance cell, that is IQAC, Guwahati University, for screening of the candidates suitability for the purpose of assessment of eligibility for the recruit. This was done to maintain a minimum standard as per selection, as per decision of Guwahati University Authority, keeping in mind the relevant UGC regulation. In the instead case, the IQAC of the Guwahati University forwarded its report after due scrutiny, having assisted by expert concerned at so-and-so. It is stated that IQAC in its report shortlisted 16 numbers of candidates out of 30 numbers of candidates, so that the shortlisters could be called for interview. While the read petitioner, Dr. Satyajit Das, was not shortlisted with the remarks, this is important, Your Lordship, that he had weak academic career, also indicating the ground for rejection that he does not fulfill shortlisting criteria mandated by EC. Moreover, as per the advertisement dated so-and-so, mere fulfillment of qualification will not entitle the applicant for inviting to an interview, and consequently, the writ petition of the instant case was not called for the interview. So basically, they found that he has a weak academic career. That was the remarks given, and he does not fulfill the criteria shortlisted by EC. Now, they did not say which is the EC criteria. They gave leave without annexing that document. But I have annexed it. I'll come to that. Okay.
EC is executive committee.
EC is the
Executive committee of the
executive.
university.
Now, Your Lordship will kindly take up my reply, affidavit in reply to that affidavit in opposition. Yet, the EC's resolution which they have stated is, I have annexed that at page 47. So good. Save me. Affidavit in reply, I don't know whether the paginations are correct or not, because at that point of time, it was not serially page.
No, it's really 47. It starts at 47.
This is the first meeting of the committee.
No, 47 your affidavit starts.
Yeah. Oh, it starts from 40.
You can give your internal page. We can try to give your internal page.
Just a moment, Your Lordship. I am.
You have not annexed anything here in your reply affidavit.
Okay, in that affidavit. Uh-huh. 43 affidavit in reply here. In this, I have not annexed. In this, I have not annexed. Your Lordship, what has happened? What I have annexed para 5, Your Lordship will kindly take up para
5.
5.
Yes, yes.
This is internal page 3.
Yes, yes, we have seen.
That with regard to statement made in para 4 of the affidavit, the deponent begs to state the respondent had not specified under what criteria the 16 numbers of candidates out of the 30 numbers of candidates have been shortlisted by IQAC of Guwahati University. The deponent states that the IQAC Guwahati cannot override the provisions of UGC regulation 2018. Clause 3.1 indicates as follows. So I have indicated that here the post, Your Lordship, what is the basically the IQAC's role has been given here. Direct recruitment to the post of assistant professor so-and-so in the University of Colleges senior professor in university shall be on the basis of merit through an all India advertisement, followed by selection by duly constituted selection committee as per the provision made under the regulation. These provisions shall be incorporated in the statute ordinances of the university concerned. The composition of such committees shall be specified in the regulation. As such, the UGC regulation have categorically discarded any other mode of selection and recruitment apart from which the formulated by UGC. The IQAC Guwahati have to follow the UGC regulation mandated for the purpose of recruitment. Under the above circumstances, rejecting the application of the petitioner with remark, weak academic career cannot be a ground from preventing the petitioner from appearing in the interview. This part actually what has happened, I have given it here in an affidavit, whereas in the second affidavit that there is another affidavit that we have filed. There's another affidavit we have filed that Your Lordship will find from page, I think 94. Page 94, your lordship has got that. This is our affidavit in, they have again filed another affidavit. There were two affidavits filed by the writ petition, by the university. There are two affidavits by the university. The second affidavit that your lordship will find filed by the university, that starts from 88. 88.
Yes.
Here, your lordship, at page 90,
Hmm.
90, your lordship will kindly see 90.
Yes.
That's given as para 3.1, Roman 1, last paragraph.
Yes.
That is important. Here they have stated why they have done it. As regard the writ petitioner, Dr. Satyajit Das, in writ petition number, the advertisement was published in 2018 with the last date of receipt of application being 36/2018 to the writ petition bearing writ petition number so and so. While the UGC regulation of 2010 was in force, whereas the UGC regulations of 2018 came into effect subsequently on 18/7/2018. Annexure 5 to the affidavit of respondent number 5 may be referred to, which regulations 2018 have been afterward adopted by the Guwahati University authorities in its EC meeting held on 25/1/2020. Now they want to say that that selection was on the basis of 2010 UGC regulation, not 2018. Into. Then in the Roman 3, they have stated the recommendations as incorporated in the minutes of the meeting held on in connection with the shortlisting criteria required for recruitment of assistant professor so and so do not have any retrospective effect and as such not at all relevant to the selection process initiated through advertisement dated 2018 as regards the writ petitioner's strength, unlike that of the writ petitioner in WPC 6853. Now 6853 is the second writ petition. So they have made a difference between these two. They said that the second was with regard to 2018. This is with regard to 2010. Now your lordship will kindly take up my reply to that. It starts from page 94. Here I have annexed that regulation here. Page 100. Page 100. The first meeting of the committee for finalizing the following matters was held on 22/11/2018. Here it is in the way so and so. Shortlisting criteria for recruitment of assisting professor. What will be the criteria? Number 1, CAS application format as per UGC regulation 2018. Now they are following 2018 in this. Now application format for direct recruitment as per UGC regulation of 2018. IQAC scorecard as per UGC regulation of 2018. Meeting so and so, so and so. Minutes of the meeting, just one I'll read. Committee recommends the shortlisting for recruitment of assistant professor to be based on a score of 100 marks distributed across 9 parameters. Now that is in next page that your lordship will find at page 101. These are the parameters given, your lordship. In
Yes.
these parameters, the marks have to be given. This is the IQAC's scorecard they have to follow. Now your lordship will kindly turn to page 102. 102, your lordship, we filed an RTI before the authorities asking for 2 things, your lord. One is the resolution of the EC meeting held on 25/1/2020 on the UGC regulation 2018 regarding the number of candidates to be called for interview, so and so. 2 is provide me the shortlisting criteria for listing of candidates to be called for interview regarding appointment of assistant professor mandated by the EC held on 25/1/2020. And 3rd is provide me documents regarding rules guidelines of IQAC Guwahati on the notion of weak academic career of a candidate not to be called for an interview and selection for appointment of teaching post assistant professor level. Now the answer your lordship will find at page 10. 105. In page 105, they have issued the letter giving the answer at page 106. Kindly see the answer, Your Lordship, here. The three questions, Your Lordship, three answers. EC resolution number so and so, dated 22/1/22 enclosed regarding number of candidates to be called for the interview. The candidates shortlisted for appointment as per UGC regulation 2018 and no such extra mandate adopted by the Executive Council GU. Third important, Your Lord. The IQAC GUA has no special rules and guidelines on notion of weak academic career. Candidates not to be called for interview. The IQAC GU is following UGC regulations 2018 as well as EC decision. Candidates call for interview selection on the basis of merit, and there is no question of strong academic career or weak academic. So IQAC does not have, according to the UGC regulation, do not have any criteria. They are based only on the fact that whether he is eligible to be called for interview, and the interview will be under merit. That is what it has stated. Now, Your Lordship will kindly see the affidavit filed by respondent number 5.
Who is 5?
Respondent number 5.
5, who is 5? Private
The-
candidate.
The selected private respondent. At page 77 is the CV of that candidate, and in the CV, Your Lordship will see what is the qualification of that particular person. Page 77, annexure A to number 1, Your Lordship, at that
Just a minute. Page 77.
77. This is the CV of that particular candidate. I'm not the CV they have given what they have, what are the qualifications. So here academic qualification, Lordship will kindly see.
Yes, please.
The first one is provisionally registered for PhD, Department of Folklore Research, Guwahati. At that point of time, she was not a PhD holder when the applications were made. Number 2, Your Lordship, NET qualified under Mass Communication and Journalism, Your Lordship, in 2015. Then, Your Lordship, MA, Mass Communication, Communication and Journalism, MSc, Zoology, Postgraduate Diploma in Translation Studies, Postgraduate Diploma. This is a PG Diploma, Your Lordship, in Folklore and Cultural Studies. BSc also in Zoology, SSLC Science and all. So, this is the person who was selected. So not even music. There is nothing with regard to music. Zoology, only one postgraduate diploma in folklore studies is there. That is also a diploma.
But is music required?
So that is a desirable qualification. That's what I'm pointing it out. One part. Second part, Your Lordship, is not even a PhD holder. The petitioner is a PhD. Then, Your Lordship, she also has some kind of a little bit of experience. We are not going into that, Your Lordship. So overall, Your Lordship, these factors are there. Now, even if Your Lordship will take up the UGC regulation of 2010 for a moment, I'll give a copy of that.
I think we may be having, just a minute.
UGC regulation 2010, Your Lordship will kindly take it on DTS copy. I am not giving the whole bunch, the relevant portion I am.
Yes, please.
Here, Your Lordship, with regard to IQAC, they have stated.
But Mr. Manan, the reply which